Ladies and gentlemen, dear colleagues, good morning. Let me introduce myself. My name is Jenny Stavridi. I'm the legal advisor of the Ministry of Foreign Affairs, the head of the legal department. I'm very honored and happy to chair this last panel of the conference today. I will say no more. I will just introduce the first speaker, who is Professor Concepción Escobar Hernández, who, for me, I met her as an ILC member and special rapporteur. It is a great pleasure to hear her speech, her presentation on the draft articles of the ILC. Please, Mrs. Escobar.
Good morning. Good morning, everybody. Could you hear me? Yes? Okay. Thank you. Good morning. And before starting, I would like to thank the organizers and in particular Panos. I don't know where it is. Panos, thank you very much for the invitation. It's a great pleasure to be able to participate in this conference and to contribute to this project, even is at the end of the project. Thank you very much. Well, and I am happy to speak at the end of the conference for several reasons, but in particular because I think that the work of the international, we have here listened a lot of things about the customary law interpretation during yesterday and today, but I think that the work of the International Law Commission on immunity of state officials from foreign criminal jurisdiction has been a good laboratory for the issue of the interpretation of customary international law, also for the identification, but I will address both issues together because it's very difficult in the work of the Commission to make a clear distinction between two elements. Let me begin by emphasizing that the question of custom has been present in the Commission work on this subject from the very beginning, and you can find, has constituted a continuum, and you can find some elements related to customary law, both in the different instruments having been used, considered by the Commission for preparing the draft articles, the memorandum of the Secretariat, the reports of from the both special rapporteurs, Ambassador Kolotkin and myself, and of course the issue of the customary law has been present in the debates from the very beginning. As a first general remark, I would like to point out that the role of custom in ILC work on this subject has had a very important weight, although its treatment and analysis has not always been explicit. It can even be said that sometimes custom has been the elephant in the room, having appeared openly only at the moment the Commission started to deal with limitation and exceptions to immunities of state officials. As a consequence, until 2016, more or less, the issue of the identification of and interpretation of customary law was not a crucial issue in the ILC work. Actually, before 2016, the ILC members have limited themselves to make some general assertions about the existence of customary law. It exists a customary law related to immunity of a state official from foreign criminal jurisdiction, but without a deep analysis and without offering any substantive reasons for supporting that assessment. And of course, without any reference to the issue of interpretation. They have limited to the system, they have limited to the identification, but not to the interpretation of customary law. Well, I think that there are some relevant reasons for this ambiguous and vague treatment of the customary law in the work of the Commission on this topic. The Commission purpose has not been merely to codify pre-existing customary rules, but to draw up a general proposal for a comprehensive and autonomous legal regime applicable to immunity. Thus, the identification or interpretation of custom was only one of the instruments for reaching this outcome. However, given the small volume of the small number of treaty rules that refers directly and expressly to the topic, the examination and assessment of non-conventional state practice, and of course the analysis of customary rules on this area became a privileged instrument. In addition, I would like to say that the question of custom, especially from the perspective of identification, has been increasingly linked with to another parallel debate, very important, which, although it seemed to have been fished in the past, arise once again at the moment of the treatment of the immunity. It is the delimitation of the dual mandate of the Commission, progressive development and codification, the definition of a model of relationship between the two elements, and the debate about how it should be applied in the elaboration of a draft articles which purpose is not necessarily to prepare a draft treaty, because the Commission has not decided until now about that. The Commission has decided to prepare a draft articles because the topic, the issue has a strong normative component, but the Commission didn't decide about that. The Commission will take a decision next year. But in that context, for some members of the Commission, the mandate of the ILC with respect to this topic was basically anchorage, almost for some of them exclusive anchorage, in what is law, lex lata, and in the undisputed state practice. And therefore, custom is called to play a central role in this work, as it is evident. Of course, from the perspective of those members of the Commission, a role oriented essentially towards the identification of customs. This reductionist approach has not been, however, the only one present in the Commission work. On the contrary, a broader debate has included the components of evaluation and interpretation of customary law. During the three quinquennium in which the Commission has been dealing with the issue of immunity of state officials, the relationship of custom with this institution has been approached from two distant but complementary perspectives. First of all, the existence or not of customary rules relating to the immunity of a state official from foreign criminal jurisdiction on one hand, and the determination of the content of those rules on the other. The first approach essentially concerns the identification of custom. The second incorporates elements directly linked to the interpretation of custom. Indeed, as a link between both approaches, the Commission has not been oblivious to the evaluation or assessment of practice and opinion juris, which I will develop later, has been a necessary instrument both for the identification and for the interpretation of custom referring to immunity. I would like to put emphasis on this idea because I think it's one of the elements included in draft Article 3 of the prepared by the team working on this issue, and I think it's important to take that into account. The problem of custom has been addressed in a transversal manner through the work of the Commission, and its shadow has been cast over a very varied aspect of the subject. But certainly, when the question of custom has appeared more radically with a greater weight and generating a greater controversy has been in relation to the issue of limits and exceptions to immunity that have been reflected in Article 7 of the draft articles adopted in first reading last year. I shall therefore focus on this issue. I'll start by making some comments about my fifth report, because my fifth report is the origin of the debate on this issue. And in that report, I have approached the issue of customary international law in order to found a basis for limitation and exceptions to immunities. The idea was to identify if it was possible in the practice to find some kind of elements, not only in state practice, but only international practice, judicial practice at national and international level, if it was possible to identify some elements sufficient to justify the inclusion of one draft article on this issue in the commentary. Well, after I think a deep study of the practice, I have concluded that there is sufficient basis to conclude that immunity, exceptional limitation to immunity exists. But I was at the same time, I was aware of the criticism about this conclusion, in particular, not only in several, in the practice or in the doctrine, but also between some members, a reduced number of members, but some powerful members of the Commission, if you let me to use this word, regarding the system of the customary law as it is. So I decided to look at the custom, or I decided to look at the immunities, the exceptional limitation from other perspective, which was the identification of some elements that allow us to interpret the customary law, the not controversial customary law, of course, a custom exists regarding that, but in order to identify if it was possible to interpret that rule in a way that allow us to include this article in the draft, in the project. And for so doing, I have put emphasis on two elements. First of all, the bottom purpose of the institution itself, which is very, so the teleological method of interpretation, and also in a systematic integration approach to international law. The idea was to put emphasis on the international law as an integrated, complex, and systemic order. And for that reason, it would be impossible to make interpretation about or to adopt any proposal which could be against the main rules of international law valid at that moment. I was thinking not only in immunity, of course, I was thinking in sovereignty, the principle of equal sovereignty. I was thinking in the principle of integrity, the territorial integrity of a state, the right of a state to exercise jurisdiction as a rule, as a principle, and in particular, I was thinking on the principle of accountability for regarding the most important crimes under international law and development of thank you. the development of international criminal law. Well, what was the reaction? On that basis, I conclude also that an interpretation was possible, so it was possible to found basis for this draft article from the two perspectives, identification and interpretation. The reaction from the members of the Commission was very as expected. It was very clear. For some members, they focus only in the issue of the identification because it's the traditional one and the traditional approach of the Commission to the customary international law issues. And they try to push only in the state practice, only in the state practice. For other members, on the contrary, the state practice, of course, was very, very important. The identification of the rules, the rules regarding limitation was relevant, but they have considered that it was possible to resort to identification, to principles of international law. What has been the final, the debate has been very strong, as you can know. I refer you to the annual reports of the Commission, in particular to the annual report in 22 and the commentary to article, regarding Article 7, which is very, which clarify very well the debate in the Commission, even if now the situation has changed, even last year. But what, from the perspective of the present conference, which is the most important, I could be speaking a lot about Article 7 because I said to my colleagues that the Commission is my baby, so I will stop here about draft Article 7. From the perspective of the customary law, which has been the outcome, the final outcome of the Commission? Well, the Commission, if you look at the entire test of the commentaries, and in particular, I recommend you to read go to the general commentary, where the main perspective of the Commission, the main approach of the Commission is established. The conclusion has considered that customary law continued to be an important element in international law, and in particular with regard to this topic, but that customary law, any rule of customary law, must be analyzed. We didn't use the word interpret for a kind of it's a kind of consensus in the Commission. The Commission works always on the basis of consensus, and we have decided to say that, well, customary law is important, identification is important, but we have to take into account that immunities will apply in the context of international law as a legal and complete systematic system. Second, the distinction between identification and interpretation doesn't appear in the text or in the commentaries in an expressly way, but if you look with attention, if you look at in particular at the commentaries, you can find a certain number of references to identification of the issues. Third, because of the work in this topic, the Commission has accepted that systematic integration and teleological interpretation constitute valid elements, valid methods, valid rules, principles. Is to you to decide for proceed to determination of the system, but at the same time the content of a customary rule. I have lost the relation, the use cogents has been considered, but to be honest, play a little role in the test. Once again, a matter of consensus, I have to say. And finally, the most important, the Commission has approached the issue of customary law regarding immunity, regarding limitation and exception, also from the perspective of the limits to interpretation and the orientation, inspiration, but that issue and the issue of modification by interpretation has not been fixed by the Commission. It has appeared sometimes, but it had not been fixed by the Commission. Sorry, I stop here. Sorry very much. Sorry for having taken some time, more time.
Thank you. Thank you very much, Professor Escobar. So I will pass now the microphone to Professor Maria Gavouneli.
It is always a pleasure to see old friends and colleagues and just smile to all of you in this familiar place. Right, let me pick up where Professor Escobar finished, because what she has said pretty much sets the framework of what I'm going to talk about in the next few minutes. And the first thing that you would notice is perhaps that the definition of that framework. So first things first, the legal basis, sovereign equality of states. And I think that is important. We're going to see that again as we go through the several cases. It has a reference to the Hughes Coggins item that you said played not a very important role in the proceedings of the ILC, but perhaps we should keep that in mind. Immunity is a direct product of the sovereign equality of states, and we should treat it as such. And I think, in fact, in most cases, we do, with one exception, perhaps. Types of immunity, you don't need to know that, but you do know that, I presume. But the second item that you need to take into consideration is that in the Greek context, because I'm going to talk about the Greek cases, generally accepted rules of international law, in other words, custom, are part of the law of the land and supersede statute law. So again, here you do realize that whatever goes in international law would inevitably go into domestic law as well, without any filters or anything further. And then you would also need to know how we treat absolute and relative immunity so that we can actually come up to the norms. The norms, there is scarcity of treaty law in that respect. In fact, here are our two conventions in international law, and it is very, very clear that especially the UN Convention, in fact, encapsulates customary law, so much so that nobody paid any attention to the convention because everybody understood that it was actually customary law, and therefore, what's the point of this whole exercise? And the convention is starting, actually, with that statement that it is actually a mirror of generally accepted rules of customary international law. So let's see what are the parameters of these customary rules, and here we would get inevitably into the situation of production of customary rules, identification of customary rules. I saw with interest the relevant articles in the draft articles you have produced, partners. So, essential element number one, here we're talking about customary norms that are in fact developed by domestic case law. And I think that is the most exceptional element when we're talking about immunity. Immunity is an international law concept produced and developed exclusively by domestic courts. It's not just practice, it is actually courts. And that is important because domestic judges do not usually apply international law. They do, much more than they expect. But, you know, the first thing, the first thought actually is not that. And there's also the additional element, first, of fragmentation, because clearly as many states you have that many types of course, at least, and if you go into federal states, you would also have many more. And second, the language element. We tend to forget that. But when we're talking about domestic case law, somebody has to have access to that domestic case law. So there's really an issue here. So we all agree that this is developed by domestic case law. In the continental systems, that is very, very clear that it is part of the law of the land, and you saw the example of the Greek constitution. But in the common law jurisdictions, we always had this question of precedent and stare decisis and things like that. It can be overcome if you really have a very good judge. Lord Denning was there, and I have put the relevant paragraph because you see how somebody who is enlightened enough can actually walk around the problems. Trendex was really an excellent case, but people felt that they could not rely on that dictum to move on. And we came up with a number of statute rules in common law jurisdictions because people felt that they had to have statutory clearance, if you like, in order to bypass the stare decisis situation. With one interesting exception, Argentina, a civil law country, felt that they absolutely must have their own case as well. Indeed, there you are. So I think that is interesting, that interplay, if you like, and the conundrum of having civil law countries, traditionally code countries, relying on custom on the one hand, whereas civil law countries, which were traditionally customary law countries, relying on statute. You know, things turn around on their head. And then we end up with what might actually be the new rules of immunity. What is the issue here? The issue is a product of the restrictive theory of state immunity. The question is, do we have a tort liability exception for torts committed in the territory of the forum by organs of the foreign state present in the same territory? Why is that an exception? Because in the traditional sense, immunity refers rather to contractual obligations, not to torts. When we're talking about relative immunity, when we're talking about a state going into the marketplace, we're talking about contracts, where the state voluntarily puts itself in a situation that is subject to another jurisdiction. Here, there's nothing voluntary. When you have a tort, it is simply something that you have not really, that happened to a certain extent. So you need to take that into consideration. That was the question in terms of law. And there was an exception, the exception of the exception, if you like, military obligations which are supposed to be an exception to the tort exception, and therefore would return back to the rule, and therefore they would be covered by immunity. That came into fore in the context of the Viotia case against Germany. The facts of the case, for those of you not familiar with them, it was June 1945. The German occupation army was removing itself from the country, and on their way out, they effectively destroyed the village of Distomo in Viotia, several kilometers north of Athens. What was that? Was that a tort? and therefore an exception to state immunity, or was that a military operation, and therefore it was the exception of the exception and the rule of immunity would apply? The case ended up before Areospagos in a rather convoluted way, the Areospagos being the Supreme Court in the land. And here we have a very interesting decision, a decision that was split three ways. So the court reasoning, the majority, came up with this kind of thing. First, there exists a customary exception from state immunity for torts committed in the territory of the forum, even if these acts are acta iure imperii, because military operations, by definition, are iure imperii. Therefore, the court was very clear that here we have a development in international law. The court further said that the tort liability exception applies also to claims arising out of military operations, so no exception of the exception. And then there was this rather obscure sort of understanding, an argument that said that in any way the acts involved were so atrocious as to imply a certain waiver from all rules, rule of law, basically. The idea of somebody being outlawed, which I find exceptionally problematic. But the court did not come up and say so explicitly. It tacitly referred to a tacit waiver, if you know what I mean. An extremely complicated kind of situation, and clearly not something people felt comfortable with. I have to tell you from personal knowledge that the judges in that case were really, really worried about things. I do recall the rapporteur coming over and saying, okay, what is it that I need to know absolutely? You know, bring everything down, sit next to me, do, explain, you know, everything from straight. So they really struggled with that. Two dissenting opinions to which the president of the court ascribed, and that is really, really exceptional, a situation where the president of Areospagos was actually in the dissenting opinion. There is no customary rule of tort liability, so a total and complete negation of the premise of the majority. They said that in all other situations where we have tort liability, it was an application of domestic law rather than international law, and they recited certain cases, most of them in the US. But they did not further explore the ways in which customary law is being developed. They just came up with a question of this exists or it does not exist. Under which particular points, what are the parameters of that, was really left hanging. The second dissenting opinion simply said, okay, it might be a tort exception. They did not really express an opinion on that. But either way, they said, it doesn't matter, because here we're talking about military operations, and military operations would fall under the armed conflict exception, and therefore the rule is retained. So what is it that we're talking about? Then they have actually elaborated further into this tacit waiver kind of argument, suggesting that here what we have is actually a breach of jus cogens. In other words, we had crimes against humanity, and therefore no immunity could actually be attached to this kind of thing. There's clearly a tacit waiver of state immunity. I have a number of problems with that. First and foremost, why crimes against humanity? Here we're clearly at a time of war. Is it possible that we live in this glorious bubble of peace and serenity in June 1945 so that we can have crimes against humanity? Why not war crimes? I'm not even getting into the intertemporal kind of things, okay, because this is 1945. But there you are. So there are assumptions being made that somehow, to my mind at least, need something further. The judges were really exercised with this tacit waiver kind of thing. I think they liked it, but they could not really get it entirely correctly, and they tried to be as much as possible. That decision in 3 different parts was actually moving around the world in 80 courts. You can find it just about everywhere under the sun in domestic jurisdictions, being referred to by different judges who ended up getting into a dialogue with their Greek counterparts, notwithstanding the Greek language. So there you are. So, and you can read, for instance, in the Buzari case, the judge says, my Greek colleague said this and that, I respectfully disagree. I mean, you know, they talk to each other. You know, it's really, really powerful occasionally. And of course, that goes all the way to international courts and tribunals, the European Court of Human Rights, the European Court of Justice, with an excellent quote from Thucydides: war is the father of everything, and eventually the International Court of Justice. The rebuttal came from domestic courts themselves, from the Greek courts. And this case was another destroyed village somewhere in Epira, in the mainland Greece, the Miltiadis Margellos case. Here, the case did not go to Areospagos simply because Areospagos had already pronounced on the Distomo case, and therefore it went to the Special Supreme Court with a question. That is a special court that has to determine the existence of a customary rule, and in so doing, that customary rule is understood as being part of the law of the land under Article 28 of the Constitution. So here, this special Supreme Court, which is half judges of Areospagos, so civil judges, and the other half coming from the Conseil d'Etat, in other words, administrative judges, they have to figure it out whether a rule is actually a rule of customary international law or not. Interestingly enough, no international law professors involved in that thing. So there you are. We have a similar case coming all the way up. And here, the Special Supreme Court was very, very clear. Sorry, guys, no tort liability. At the present stage of international law, there is no such exception. And if there is such exception in the making, it has not yet emerged. And it has actually relied, and I'm finishing, on ECHR decisions, especially McElhinney against Ireland, because that was the one that was mostly close to the Greek case. In Ireland, they have a similar understanding in the Constitution, and they do apply the same rules as Greek courts. And then, of course, the original case, Distomo, ended up at the ICJ. The court came down like a ton of bricks. There is no such thing as a new rule. Go away. We apply the same rules. Immunity, however, does not mean impunity. So find other ways. International law has other ways, but do not play with the norms. And no reference to any new customary rule developing or anything like that. And then, of course, and that's where I stop, the Italians come over, and I will cede the floor to my colleague. Thank you so very much.
Thank you.
Thank you very much for this great occasion. I'm really honored to be in Greece, in Athens. Apart from the honor, I really, really enjoy being here and having the chance to debate about these fundamental issues about customary international law, which really, I'm sure, all of us have encountered at some point. Okay, I will just gone, during our teaching and studying. Thank you very much, Panos. You have done a great job, is not the right word. This study is really interesting. I think it's great that people devote so much time to these fundamental issues, which are, very often just taken for granted or put aside. Anyway, thank you to Professor Gavouneli. I will continue the dialogue. I would just like to stress a couple of points before going into the Italian decisions. And I would like to point out how the role of the national judiciaries is really relevant within the draft guidelines offered by the ILC on the identification of customary international law. Not only the judiciary is really one of the main entities to which these guidelines are directed, but actually they do play a relevant role when the matter comes to identify customary international law. Why? Conclusion 5, conduct of the state as state practice declares that state practice consists of the conduct of the state, whether in the exercise of its executive, legislative, judicial, or other functions. Forms of practice, conclusion 6, decisions of national courts. Conclusion 10, forms of evidence of acceptance as law includes decisions of national courts. A last role is also the fact that decisions of municipal courts are a subsidiary means for the determination of customary international law. So it is clear here that really the judiciary is I would say, certainly a relevant actor in the making, according to the ILC, but I'm going to argue that it's really a main actor in the interpretation of customary international law due to some specifications. Professor Gavouneli was speaking about Article 28 of the Greek Constitution. In Italy, we have an Article 10 of the Constitution, which actually was not worded in terms of is part of the law of the land, because our strict, as you all know, dualist approach to international law and municipal law made Perassi, who is this great international law professors, want to specify that it's really Article 10 transforms the rules of customary international law into municipal rules. Municipal rules which have a constitutional standing thanks to Article 10. Following this operation, though, any judge will apply, when necessary, where relevant, customary international law. There is no procedure in the Italian legal system by which you have to ask for the advice. I know there is in the German Constitution the advice of a higher court, or the so-called verification procedure, or I understand in France this is done in a way which is not official, but somehow they told me it's done. Some countries have actually a procedure by which it is the executive power which gives you the interpretation of custom, like Hungary at this time. So because of this, I would say that Italian courts do apply and interpret a lot of customary law, but of course I will keep to the question of immunities of the state, because it is relevant here. The Ferrini judgment was already mentioned. The Ferrini judgment 2004 is a judgment by the Corte di Cassazione. And what is it about? The issue here again is the action for reparation of damages suffered by Italian military, members of the military who between September 43 and April 45 were taken by the Nazi, which were retiring towards the north of Italy, and brought into Germany and put to labor. This is, as you all know, it was disputed whether these were really prisoners of war or not. Professor Tomushata gave a very debated opinion about whether they were or not entitled to the treatment of prisoners of war, whether they were denied, what kind of labor they were doing, and so forth and so on. The reason I find that all these contentious cases come up at this time, probably in Greece as well, is that after 1990, Germany adopted some laws in order to give reparations to individuals. And however, large groups of people who thought they had a claim to some reparation were excluded from the application of this law. They went to court. I think they went up to the Bundesverfassungsgericht, but didn't get anything. So that's the reason they started taking their actions into municipal courts. Okay, so in 2004, the Cassation Court, hearing an appeal from lower courts about the jurisdiction over Germany for these kind of actions, answered that yes, there was the Italian jurisdiction. Why? Why? And this is the main issue of this judgment. The court interpreted the rule of foreign state immunity. It did quote the Distancia case and the Distancia decisions as a relevant precedent, but said, they are using this implied waiver argument. We don't find it convincing. Maybe it was 2004, and so there were also the later decisions. We don't find it convincing because we cannot really presume a will of the state here to waive its immunity. And what did the court then do? It thought that there was a conflict, an antinomy between two rules of customary law. One rule, the state immunity rule, restricted in its restricted version, as Professor Gavouneli has already said, and the rule which prohibits war crimes. I think humanitarian may be used because, because of Nuremberg, we'll put them all together because there were civilian population which are still war crimes, but maybe that was might have been the reason. So there is a conflict because if you cannot do these kind of actions, then if you do them, you are responsible. You have to respond, be liable for for the damages you have caused. The Court of Cassation thought that this conflict could be resolved through the hierarchical application of the rules. This is the Jus rules. The immunity is just a customary rule, so the Jus rules will prevail. But on the other hand, by saying this, it also recalled Article 41 of the RCBA, which spells out all the obligations of all states concerning the consequences of a serious violation of an obligation imposed by a peremptory norm. It said that by recognizing immunity, the Italian state would violate those obligations and therefore could not do it. It also, however, took into consideration other arguments. For example, it dismissed openly the fact that there was no express rule on customary law making an exception for this particular case. So this is not really decisive. Why? Because in view of the peremptory rules, these are fundamental rules of the legal system, of the international legal system, and I have to interpret this relationship among the different rules. What did the court say? Actually, the court took into consideration the jurisprudence of the European Court of Human Rights, those two cases in particular, and then said that those cases really concerned facts which were different from the ones in front of the court, that here the facts had occurred on the territory of the state to the damage of people residing and living in the state. So the idea of the tort exception was really very present. But I would like, this is my translation, so please bear with me if it's not a great translation. The Corte di Cassazione said, legal rules must not be interpreted separately, one from the other, because they complete and integrate one another by reciprocally conditioning their application. Those judgments refer to specific treaty provisions, but there is no doubt that equivalent, the court used analogous in Italian, criteria apply to the interpretation of customary rules, which, like the others, are part of a system and thus may be rightly understood only if connected to the other rules, which are an integral part of the same legal system. So I'm sure that you have found and studied this passage of the judgment, but if we needed some confirmation of the fact that you interpret customary rules, this is really extremely clear. 2 points I really would like to stress, and the first is that the court does its reasoning all on the international law level. It does, I told you now, it's a strict dualist approach, but what does the court say? This is what the international rule, the content, the interpretation of the international law, customary rule on the international law plane, and then I bring this content into my municipal system and apply it. So, and the other thing is that the court felt naturally empowered to do this kind of interpretation. You know, it's not why, it's a higher court, you know, it does this job every day. So what was it gonna do? It was gonna just be a court which was applying the rules, and in order to apply the rules, it had to interpret the rules. So if I have to go back to the different roles that the ILC conclusions attribute to national judiciaries, I would say that this is certainly application through interpretation. You all know what the ICJ said 8 years later. I would only say this. It's not because there is no conflict, as the ICJ said, that we don't need to interpret the rules. No, we need to interpret the rules even if there is no conflict among the rules in order to understand what is their scope. But we all know that the court went a completely different way. So judgment 238 of 2014, Italian Constitutional Court. The Italian Constitutional Court did not like the judgment by the ICJ, and as you all know, went on to say what? That these customary rules do not enter the Italian municipal system because they are in contrast with fundamental principle of the Italian system. In particular, the right to a judge, the right to remedial access. So here, the court seems to just consider the municipal level, but it does say some things which to me are a bit disturbing. Why? It does not say that, the court says that it was compelled to interpret the rule of state immunity as interpreted by the ICJ. But why? Not because the judgment was binding for Italy, but because the ICJ was a particularly authoritative judge on the international law level, and therefore the Constitutional Court must take, must accept these, which, you know, we can try to debate whether it's just the operative part which is binding, the argument is not binding, the motivations, but it seems really strained. I think it's just because our court, our Constitutional Court, does a similar, sorry, I'm really running out of time, is really running the same line of argument with the European Court of Human Rights, but that's aside. But what it says, which to me is disturbing, is the fact that after having maybe repeated that the international law rules must be interpreted according to the interpretation which is given to them on the international level, then it says something else. Again, my translation. One must admit that on the international law level, the interpretation given by the ICJ of the customary rule on state immunity from jurisdiction is a particularly qualified one, which does not allow for a review by national administrators or judges, this court included. So that seems to say it's not that it's binding, it's authoritative, but because it's authoritative, national judges may not put that into question. So to me, this is troubling, but this is what the court said. The court also added, according to the restricted state immunity rule, an evolution in this sense, tort exception, has been caused by the restriction of the traditional absolute immunity rule has been caused by decisions of municipal courts, who naturally must evaluate their jurisdiction. And we are agreed with this. While it is left to international bodies the exam of practice in view of the ascertainment and development of customary rules. So this seems to say that, yes, you can contribute by giving judgments, but don't say anything about international law, because that is something that only international bodies can do. And this, to me, again, is not a good line of argument. Okay, the court at a certain point also says that in protecting this fundamental human right, I hope other courts will follow, other municipal courts will follow. And certainly, Tesauro has said so openly, there was this intent of starting a practice, as we are told in our textbooks that the Belgian courts, the Italian courts were the first one to promote the restricted immunity rule. But the fact is that by not going into the argument on the international law level, what the court really has done here, if it is a piece of practice, it's about the prevalence, relationship between municipal and international law, and prevalence of the municipal law over the international law. It has not promoted a rule concerning the tort exception. Okay, sorry. I know I'm out of time, just one last thing. Last July, we had another Constitutional Court decision. As you all know, Italy was reconvened to the International Court of Justice by Germany in 2022 because of all these judgments which had arrived at the stage of execution of the judgment. And at this point, the region, the Greek region, also applied for execution. And then there was the issue of which properties of the state could be attached. And so Germany went back to the ICJ, instituting a new action. So the Italian government clearly had to come out of this situation, and it established a fund for the full reparation of all the victims of these crimes. And I'm sorry I cannot dwell about it enough, but the reasoning here is completely different. Why the Constitutional Court says that, okay, this law is constitutional, it does not breach the right to a judge of these claimants, because these funds give full reparation, but also because there is another constitutional interest which has to be balanced with this individual right, which had not been mentioned before, and that is the respect of international law, and in particular international treaties by Italy, which had never come around, in the former reasoning, but which is actually, it was something considered like the Völkerrechtsfreundlichkeit, something considered a very strong founding principle of the Italian Constitution. So I would say that here the court has not engaged with the interpretation of the customary rule on immunity of state properties at this time. This was not at issue in the jurisdictional immunities case. It was at issue in the it was not at issue in the Ferrini case in 2004. It was at issue in the ICJ jurisdictional immunities case, but here the court would not go into that. Thank you, and sorry for being a little bit too late.
Thank you, Professor Gianelli. And now I give the floor to the last speaker, who is Professor Urgurinis. You have the floor.
Thank you very much, Dr. Stavridi. So, hello everyone. I am very happy. I'm very happy to participate in this conference, and it is a great honor to do so. And I must say that there are many things regarding which me and Professor Mercouris disagree. But one thing we certainly agree, even implicitly, is that interpretation is not an art. It can be treated as a science, and it should be, in order to avoid judicial activism. But I'll come back to that later on. Now, in the next 13 or 14 minutes I have in my disposal, I will be addressing issues with respect to how the interpretation of customary international law regarding the law on diplomatic and consular immunities, diplomatic immunities I'm going to be focusing actually on today, fits with the draft articles that the TRICI-Law project has generously provided us. And let me start by pointing out a number of issues which I think perhaps the project may consider in the context of the further elaboration and refinement of the draft articles. It appears that by reading the draft articles, there is an emphasis on the so-called judicial interpretation. Now, Professor Zorza Bissab is famous for having coined the distinction between authentic, conventional, auto-interpretation, and and judicial interpretation. Now, usually lawyers tend to refer to judicial interpretation because they are trying to find the objective meaning, the one single truth that is out there and that can bear any and all criticism. But it is, in my opinion, necessary, if it were necessary in the context of interpretation of treaty rules, to draw the distinction, or at least keep it in mind. I think this becomes even more evident when it comes to interpreting customary international law. Now, in order to make this point, I will try and draw from a number of examples, also benefiting from the three excellent presentations made by the distinguished speakers in this panel, who almost, I think all of them refer to judicial decisions and domestic judges as factors for not only the creation of customary international law, formation in terms of practice, but also for its interpretation. Now, obviously, what I just exposed myself to was a small double hatting. So suddenly, I just refer to domestic judges as both creators of customary international law, as well as those who are called upon to interpret it. I am not sure whether and how a distinction can easily be drawn between these two processes. I know that for sure double counting is the rule here when it comes to reading books and articles and analysis in any discussion regarding the content of customary international law. Now, I will turn to two relatively light or funny examples from diplomatic and consular law to discuss and see how interpretation of customary rules is particularly interesting and perhaps challenging. Now, many in this room may have heard of the so-called notorious cases about the diplomatic bag. Now, in diplomatic law, diplomatic bag can be a bag, a plastic bag, can be a bag which is can be a suitcase, but it can even be a container. The Vienna Customary International Law, as reflected in the 1961 Vienna Convention on Diplomatic Relations, does not provide any guidance regarding the size of the diplomatic bag. Now, it has been the case that diplomatic bags may contain cigarettes, alcohol, very, very important documents in exchange between the Ministry of Foreign Affairs and the diplomatic post, but also persons. Now we have a series of cases. One was also in Italy, where there was the apprehension of a diplomatic bag, a case actually, a crate, diplomatic crate, from the Egyptian embassy headed towards Cairo, and inside the crate was an Israeli national who was sent there in order to be tried for treason and for espionage. Now, the issue with the diplomatic bag, of course, is that, as we all know in the context of diplomatic law, you cannot open the diplomatic bag. The rule appears unqualified. There are no exceptions there. There are no qualifications. Even as in another case, now before the UK authorities, when you had a bag that obviously had holes in order for the intoxicated individual to be able to breathe, and there were also smells because obviously he was not in a very good state, as he was transported by the Nigerian authorities in London to Lagos in order again to be tried because of his political beliefs. Now, the first question that arises here is this a case of, one would say, auto-interpretation? Auto-interpretation, and I again refer to Professor Zorza Bissap's distinction, is when a state itself comes and interprets a rule. So in the context of interpretation of customary law, would that be a case of auto-interpretation? One would be easy to say yes, in the sense that the state organ involved here comes from the executive. But if it were a court, if there was an injunction, if there was a court to decide whether or not to open the crate, would you still consider it as an auto-interpretation, or would you be more inclined to refer to it as a judicial interpretation? Again, with all the issues regarding double counting and so on and so forth. But I think things become a bit more interesting if one turns to, as I said, to the draft articles on interpretation of customary international law, very elegantly developed by the TRICI-Law project. Now, I would focus on the articles regarding teleological interpretation and systemic interpretation. Now, one would ask, the case of opening a diplomatic crate because there are very strong reasons to believe, or even certainty, that there is a living person inside. Would that be a case of interpreting the customary rule against the violability of the diplomatic bag, or would that be the case of an exception? Now, in the case of treaty interpretation, there has long been established, at least in international and investment law and arbitration, that if you want to have an exception, or you want to apply an exception, and now listen, I just said it, you want to apply an exception, this is not a matter of interpretation. An exception is either part of the same rule, part of the same primary rule, or at least a distinct rule. Whether you apply it has nothing to do with an interpretive exercise. Now, this is where decisions, normative decisions, have to be made. This is a point where one must consider whether the exception in the two cases, because trust me, in all these cases, we discussed them because the authorities actually opened up the diplomatic bags and removed the person. In those two, in those and other cases, should we consider them as instances of the interpretation of the customary rule? Teleological, evolutive, many things could be said. Teleological interpretation, obviously we say that the telos of diplomatic law more generally and the protection of diplomatic bag rule in particular, the customary rule, is about protecting communications, not about smuggling persons. It could also be the case with systemic interpretation. That international human rights law, as it has evolved, again, even Huskogians, one would say, to the extent that, and I hope it is, that if you are drugged and put inside the crate, it is inhumane and degrading treatment, which is a Huskogians. I hope it is. These are the questions I would like to pose. I don't have clear-cut answers, but I will again want to thank Professor Mercouris for giving me the opportunity to reflect, as member of this panel of distinguished experts and before a qualified audience as yourselves. So thank you very much.